Every day, thousands of citizens enter interrogations, assuming innocence is an absolute legal shield.
They trust that the truth will naturally emerge through simple, honest conversation.
They do not realize the environment they have entered is entirely asymmetric.
The legal system assumes that no rational person would ever confess to a lie. Yet, post-conviction DNA testing repeatedly reveals a stark and troubling systemic contradiction.
This phenomenon is not an occasional error or a bizarre psychological quirk. It is the predictable output of a highly structured legal apparatus. The modern American interrogation relies on a standardized, legally sanctioned psychological matrix.
Known as the Reed technique, this system dominates police training across the nation.
It structures the interview into a non-accusatory phase, followed by a high-pressure interrogation. The explicit goal is not to gather information, but to secure a confession. Under this framework, investigators are legally permitted to use active, deliberate deception. They may lie about finding the suspect's fingerprints at the crime scene.
They can falsely claim that an eyewitness has positively identified them.
To the suspect, the evidence against them appears completely absolute and inescapable. The interrogation then shifts to offering face-saving justifications for the crime.
Minimization techniques reframe the offense as an accidental or understandable lapse in judgment.
The suspect is led to believe that confessing is their only path to leniency. Under prolonged stress, the mind shifts from long-term consequences to immediate escape.
Historically, common law courts viewed confessions with a high degree of skepticism. Early American jurisprudence required absolute proof that a confession was entirely voluntary.
Any hint of physical torture, threats, or explicit promises invalidated the statement. The legal standard focused heavily on whether the confession was factually reliable.
If the circumstances suggested the suspect spoke out of fear, the evidence was excluded.
For decades, voluntariness and trustworthiness were treated as inextricably linked concepts.
But as police methods shifted from physical coercion to psychological manipulation, the law evolved. Mid-century appellate courts struggled to define the precise boundaries of psychological pressure. In 1966, the Supreme Court mandated the famous Miranda warnings to combat coercion. Miranda solved the procedural problem of notice, but left interrogation mechanics largely untouched. The legal system still lacked a clear rule for mentally vulnerable suspects. Lower courts remained divided on confessions obtained from individuals with severe cognitive impairments. The intersection of mental illness and police persuasion remained a dangerous legal gray zone. Then, a specific case from Denver, Colorado, altered American constitutional law permanently.
In 1983, Francis Connolly approached an officer and confessed to a murder.
Connolly was experiencing severe schizophrenia, believing the voice of God commanded his confession. The trial court initially suppressed his statements as involuntary due to his psychosis. The state of Colorado appealed, bringing the case to the highest court.
The justices were forced to decide the constitutional definition of a voluntary statement. Their final ruling would fundamentally sever the link between voluntariness and factual truth. In Colorado v. Connolly, 1986, the Supreme Court re-engineered the law.
The court ruled that constitutional voluntariness depends exclusively on police misconduct.
Unless the police use illegal coercion, a confession is legally voluntary under the law.
The suspect's internal mental state, or madness, cannot invalidate the confession alone.
This decision stripped the federal voluntariness standard of any factual reliability requirement. A confession can be completely insane, yet completely admissible under the Constitution. The reliability of the confession was shifted entirely from the judge to the jury.
Juries, however, possessed a profound and documented cognitive bias regarding confessions.
Studies show juries convict on confession evidence even when contradicted by physical facts. The law creates a flawless pipeline for false statements to become final convictions. The Innocence Project reports that over 25% of DNA exonerees falsely confessed. These individuals were not career criminals. They were ordinary citizens overwhelmed by process. The Reed technique exploits this systemic vulnerability through a 9-step procedural sequence. Step 1 isolates the suspect, increasing anxiety and dependence on the interrogator.
Sign the waiver right here, right now.
But I didn't, I just wanted to.
I told you to sign the paper. We have evidence.
Physical discomfort, fatigue, and hunger gradually erode the suspect's cognitive defenses. The suspect eventually internalizes the false narrative provided by the state's investigators. This is known clean room contamination, where police feed details to the suspect. The final confession contains accurate crime scene details known only to the killer. But those details were actually introduced by the interrogators during the hours prior. On tape, the confession sounds authentic, detailed, and completely self-generated. The jury never sees the preceding 8 hours of intense psychological conditioning. They only witness the final, rehearsed narrative, delivered in a calm voice. The system records this as a successful confession, closing the investigation permanently. The procedural trap is now sprung, and the law offers few exits.
Here lies the central paradox of the American post-conviction legal framework. Once a confession is admitted, the burden of proof effectively shifts completely. The defendant must now prove their innocence against their own signed statement.
Appellate courts rarely overturn convictions based on claims of psychological coercion.
Under Connolly, if the police followed basic procedure, the confession stands firm. The factual falsity of the confession is legally irrelevant during appellate review.
The system prioritizes the finality of judgments over the absolute truth. Without physical DNA evidence, a false confession is almost impossible to undo. Yet, 80% of violent crimes offer no usable biological DNA evidence.
For those cases, the false confession remains a permanent, uncorrectable legal reality. The constitutional right to due process protects the form, not the substance. If the ritual of the law is performed correctly, the outcome is valid. This creates an extraordinary tension between institutional efficiency and basic human justice. The state expends its resources protecting the integrity of the conviction itself. To admit systemic error would threaten the stability of thousands of cases. Thus, the legal fiction of the voluntary false confession is actively maintained. The system cannot distinguish between a true admission and a broken will. Every safeguard designed to protect the innocent is neutralized by the signature.
The law treats the confession as the ultimate king of evidence.
In doing so, it creates a trap from which truth cannot escape. The human cost of this procedural architecture is borne by the vulnerable.
The young, the intellectually disabled, and the terrified are most at risk. Under stress, their compliance is bought with promises of going home tonight. They sign the statement, believing the error will be corrected later tomorrow. Instead, the prison gates close, based entirely on their own words. Years pass in maximum security facilities, while the actual perpetrator remains free. The damage extends outward, fracturing families and destroying community trust in law. The state spends millions defending convictions it knows are factually suspect. The legal machine operates with total indifference to the internal mental collapse. Public defenders with massive caseloads can rarely afford intensive forensic experts. The system relies on their silence and cooperation to maintain its speed. Innocence becomes a luxury that few defendants can afford to actively prove. The document remains pristine, while the life it describes is utterly broken.
Today, minor procedural reforms are slowly gaining traction across several states.
27 states now require the entire interrogation to be electronically recorded.
This simple change forces transparency, revealing the full context of the interview. Alternative models, like the British Peace Framework, are being actively studied. The peace method focuses strictly on information gathering rather than securing confessions. Data shows it maintains confession rates while drastically reducing false admissions.
But federal law remains bound by the rigid Connolly precedent from 1986.
The Supreme Court shows no immediate inclination to revisit the voluntariness standard.
The balance between police power and individual constitutional protection remains deeply contested.
Until the admissibility rules change, the pipeline will continue to function.
We return to the same quiet rooms where these legal transactions occur. The forms appear ordinary, routine, and completely neutral to the untrained eye. But beneath the bureaucracy lies a system that legally values form over truth. Any person can confess to a lie if the system creates the right conditions.